Namaskar, I'm Milind Pan Patil, Director, National Water Academy, Central Water Commission, Pune. On behalf of National Water Academy, Central Water Commission, Pune, I welcome to all senior officers from Ministry of Jal Shakti, Department of Water Resources, River Development, Ganga Regeneration, Central Water Commission, Central Water Engineering Services officers, all state governments, irrigation departments, water resources department, then other academicians, NGOs, and other professionals who are dealing with the water resources sector in India. National Water Academy started webinar series on interstate river water disputes in India, and today is the 8th webinar session of this series, and the topic will be Interstate Water Dispute Tribunal, Krishna Water Dispute Tribunal Case Study Part 1. We will see the Krishna Water Dispute Tribunal case study in 3 parts, Part 1, Part 2, and Part 3 in consecutive sessions. To speak and to share his experience on this topic today with us, and very renowned and expert officer available to talk on this topic, Shri R. Koteshwar Rao. Before start the session and hand over the session to Shri R. Koteshwar Rao, I will first briefly introduce to him. Shri R. Koteshwar Rao, having completed his engineering from CBIT Hyderabad in 1985, and he served in Navali Lignite Corporation from 1986 to 88. Later in 1988, he joined in irrigation department of Andhra Pradesh. Subsequently, after bifurcation, he have worked with Telangana State and retired in August 2020 as a superintending engineer. Considering his long and deep association with interstate river water dispute issues for almost 20 years, 2 decades, Telangana government extended his services until further order. For the past 2 decades, he have been dealing with Krishna Water Dispute Tribunal matters before KWDT and Honorable Supreme Court, Vamsdara Water Dispute Tribunal, then Godavari water issues. After bifurcation, he is dealing with Krishna and Godavari issues on behalf of Telangana government before KWDT, Honorable Supreme Court in between Maharashtra, Karnataka, and Andhra Pradesh, river management boards, Apex Council meeting, other inter meetings, etc. He has been dealing with these issues right from Deputy Executive Engineer cadre to his retirement up to Superintending Engineer. During his tenure, he had an opportunity to visit several projects in Krishna Basin, Godavari Basin, Narmada Basin, then Indus Basin, and also mingle with officers of many river management boards like KRMB, GRMB, NCA, BBMB, Tungabhadra Board. Today with us and very expert and renowned faculty available with us to discuss, to share his experience on this topic. Now I request our today's speaker, Shri Koteshwar Rao sir. Sir, kindly start your session and please guide us on our participant on this Krishna Water Dispute Tribunal report on part 1.
Very good morning, sir. Sir, very good morning and welcome all of you to this
morning, sir.
To this case study of Krishna Water Dispute Tribunal. Because these issues are being very very large and having voluminous material, and also our organizers asked me to deal in 2-3 parts. So I made it into 3 parts, and first part we are dealing today. Hope I am audible to all of you.
Yes, sir.
Oh, thank you.
You are audible.
Thank you. Thank you very much. So, out of the 3 sessions, the first part what I am going to cover today is mostly the genesis of the dispute, how Krishna Water dispute issues have started in 1950s, in the early in the 1950s, immediately after independence. And secondly, that complaints by the states, so they gist only. And finding constitution of the KWDT 1, that is Bachao Tribunal, and their findings and their scheme of allocation, and Tungabhadra and other relevant issues, and the review provision in the KWDT 1, and Supreme Court cases filed by Karnataka and Andhra Pradesh in 1997, and their orders. Up to that point, I am going to cover today. So how the genesis of the dispute have started. So, sir, until India's independence, there was very little development in utilization of Krishna and Godavari waters, because Krishna being one of the major source of water for the basin states of Maharashtra, Karnataka, Andhra Pradesh, and present Telangana. Utilization of water by these three states is a lifeline to all these three states, all these four states. So how that water has to be used is a big question. So, but when India's independence has come, there are only three states in Krishna Basin. That is, one is Bombay, second Mysore, Hyderabad, and Madras. Four states are there. I will show you. So this is the map I have extracted from the 1951 government census of India map, where if you see this green portion is Bombay state, yellow portion is Hyderabad state, and maroon portion southward is Mysore, and blue portion is Madras state, then Madras state. So out of this, so if you go to the so at that time there was no, in 1951, except very few understandings between the Madras and Hyderabad and Tungabhadra waters, there was no holistic agreement to share the waters of the interstate river of Krishna, because Krishna being originated in Bombay, then flowing into the Karnataka, then Madras and Hyderabad. So all these four states it is flowing, and it is a lifeline of four states, but there was no holistic agreement or arrangement with regard to utilization of fuller utilization of Krishna waters at that time. So in 1944, some agreements are there, and in 1892 and 1924 also few agreements are there with regard to small tributary of Krishna, but not holistic agreement. So immediately after independence, when all these states started or planning several new proposals for new projects, so Planning Commission convened an interstate meeting in 1951, and an interstate agreement was drawn up in that meeting, sir. Actually, what happened, the waters of the interstate river Krishna was assessed as 1715 at 86% dependability at that time. So, and the existing, sir, am I audible clearly?
Sir.
Yes, yes, you are audible clearly.
Okay, thank you very much.
Sir,
So out of the
good morning.
17 TMC,
Pan Patel, sir,
Yes.
it's not clearly audible. Either there is a connectivity problem or the speaker's voice has to be, adjusted. Please.
how is it, sir?
Yes, now it's okay.
Kodarji, hope it is okay now.
Yes, now it is okay.
Okay, thank you. So the available waters of Krishna was assessed as 1715 TMC at 86% dependability. So we have to note this percentage. Nowadays, 50%, 65%, 75% is being used. So 86 is the norm they have agreed in 1951. And the existing and ongoing utilizations were assessed as 744 TMC, and the balance 970 TMC was allocated among the states based on their future demands, that is to a tune of about 1940 TMC. So 1:2. So 970 TMC is the balance water available, 1940 is the demand. So actually there was no occasion for any scrutiny of the demands or utilization figures given by the states at that time in the 1951 meeting. As a result, few states which projected exaggerated needs got larger share, like Krishna Pennar of Madras state, while other states who presented realistic figures got much less share. So aggrieved by this scenario, Karnataka did not sign the 1951 agreement. As such, there was no concluded agreement as on 1951, but the projects of the states were being cleared by the Planning Commission till 1960 on the assumption that 1951 agreement was binding. Because whenever any project was placed before the Planning Commission in 1951, you know that Government of India was constructing the clearing the projects and supporting the states for constructing the irrigation projects, because at that time the funding is a big question. Further, in Krishna Basin, reorganization of not only in Krishna Basin, in entire India, reorganization of states was occurred once in 1953. That is, Madras state was trifurcated into Madras, Andhra state, and also some part of Madras state were given to Mysore state. Later, almost the entire India was Indian states were reorganized under this States Reorganization Act 1956, resulting in massive changes in states' territory and availability of water in states and also needs of the states. I will show you one map. So this is the map in 1951. The Krishna Basin. Green color is Krishna Basin, yellow is Hyderabad, blue is Madras state, and brown is Mysore state. So when the reorganization occurred in 1953, this green part with pink vertical lines, this shaded area, this vertical shaded area, pink line shaded area of Madras state was given to Mysore state. In 1956, when the reorganization of states was happened on language basis and other basis, this yellow part, slant yellow part on green was the Hyderabad, the part of Hyderabad state was added to Andhra Pradesh, and the vertical pink part lines on the yellow base, this area, that is Bidar, Raichur, Gulbarga, those districts were added to Karnataka, and this pink vertical lined areas, these areas of Bombay state, Westwell Bombay state, were given to Karnataka. So that's how. And the Madras state was completely, the Telugu speaking areas of Madras state were separated into Andhra state, and Andhra and the parts of Hyderabad state, Telugu speaking Hyderabad states, were formed as Andhra Pradesh. So that is how, this is the Krishna Basin, which resulted as a Krishna Basin, Maharashtra, the present Maharashtra, and the Karnataka, this blue color, and this pink color is Andhra Pradesh. This is existing from 1956 to 2014. After 2014, again, one second, sir. Okay. So back to the presentation, sir. So as you seen from the map, there is a vast change in the area. Please bear with me for a minute. There is some interruption. I am correcting. No, I am not coming from the meeting. The meeting lo just see. Okay. Oh, sorry, sir. Sorry for the inconvenience. Now I think I am audible. Okay, thank you. So in 1951, the Bombay was almost 40%, Hyderabad was 40%, whereas Mysore and Madras state were 10% of the catchment area. Whereas after bifurcations, reorganization of states in 1956, Bombay was around 27%, Mysore became 44%, and the combined Andhra Pradesh has become 29%. At present, 20% is Telangana and 9% is Andhra Pradesh. So as there was massive changes in state territories and availability of water, and because of the vast changes in the areas and all those things, the needs of the states will also be changed. So moreover, in 1950 and 60, more and more projects were proposed by the states like Koyna, Nagarjuna Sagar, TBP and Ghataprabha, etc. The demands by the states now much exceeded than the available water. So this resulted in complaining of the states over other projects, other states' projects. So when the projects were proposed before the Government of India for clearance, it has become a big problem to Government of India, the Central Water Commission or Planning Commission, to ascertain, to clear what projects are to be cleared or what not to be, because the availability of water is not sure. So to assess the water availability, Government of India constituted this Krishna Godavari Commission with Shri N.D. Gulati as the chairman and other members. to report on available supplies in Vijayawada at the terminal project site in Krishna, and also at other relevant sites, because at every end of the sub-basins and the strategic locations of the Krishna basin, they are asked to know the water availability. Because to clear the project, the first fundamental requirement is whether water is available at that project site or otherwise, and to what extent that further demands of the states can be met. So these two were asked to be assessed by the Krishna Godavari Commission. In Krishna Godavari Commission in 1962 gave a report. It said that it is not possible to exactly assess the water availability because there is no G&D data available at the intermediate places. Only at the end at Krishna, at Vijayawada only it is gauged at that time, but not in between at several project sites or several sub-basins or tributary wise, there was no gauging at that time. So that is the big problem. So it could not assess the water availability at the strategic points. That is one finding. Secondly, they said that there is a big shortage in Krishna to meet the demands of the state. But however, some water, the surplus waters of Godavari can be diverted to Krishna at 2-3 points so that the deficit in Krishna can be made good. This being apart, one more development has happened in 1963. The Union Minister for Irrigation and Power stated in Lok Sabha that 1951 agreement is void because you remember that Karnataka did not sign that agreement. So because one of the basin state did not sign that agreement, 1951, there is no valid agreement, but clearance of new projects cannot be held up and would be cleared on the footing that supplies to Maharashtra, Karnataka and Andhra Pradesh should not exceed 400, 600 and 800 respectively. So on tentative footing, they have started clearing the projects. So this is this raised to big questions by Karnataka and Maharashtra, and they agreed of that interim allocation. They said that this 400, 600, 800 cannot be agreed upon, and that is why Maharashtra and Karnataka in 1963 they have filed complaint under Section 3 of ISRWD Act and requested for reference of their complaints to the tribunal. So AP, Andhra Pradesh, the combined Andhra Pradesh also filed its complaint in 1968. Government of India in April 69 constituted KWDT tribunal and Godavari tribunal also with Justice R.S. Bachawati as chairman and other members for both the tribunals, and referred the complaints to the tribunal. The gist of the complaints of Maharashtra, Karnataka and Andhra Pradesh are: Maharashtra said that 1951 agreement is valid and you cannot clear projects based on that. Secondly, interim allocation of 1963, that 400, 600, 800 is not acceptable, and there should be de novo examination of allocation, and to restrain projects of Andhra Pradesh, that is they are disputing about Nagarjuna Sagar and some Sri Salem project and outside basin by Andhra Pradesh, and to direct Andhra Pradesh to divert Godavari water to Krishna to make good its outside basin diversion. So this is the gist of the complaint of Maharashtra, whereas Karnataka was complaining that 1951 MOU is not binding, reallocation of water in 1963 are not acceptable. They have also objected to Sri Salem and Nagarjuna Sagar, and also Maharashtra was diverting some part of Krishna waters through outside basin westwards for power generation through Koina and Tata Hydel projects. So Karnataka has also complained against westward diversion by Koina and for equitable distribution of water, Krishna water, among all the three states. Right. At that time, only 3 states, as from 1956 to 2014, only 3 states: Maharashtra, Mysore, and combined Andhra Pradesh. In Andhra Pradesh also filed its complaint in 1968, saying that the 1951 agreement is valid And it said that all the projects which are taken up are committed before 1951 have to be ensured daily flows and supplies on daily basis and weekly basis for the projects committed up to 1960, and restrain projects of upper states in violation of 1951, and also restrain the height of Koina storage and limit westward diversion to 67.5 only, because Maharashtra was arguing that westward diversion shall be increased to 108 TMC from Koina, and also other projects from K1 also, they should be permitted to be diverted to outside basin for power generation. After, with the complaints and the pleadings of the states, the tribunal settled following issues, sir. So the first and primary issue is whether the 1951 agreement is valid or not, whether it is enforceable or otherwise, and what directions are required for making this equitable apportionment of Krishna waters among the riparian states. And the 1892, 1933 and 1944 agreements are valid or survive. So that also an issue. And as Andhra Pradesh was pleading for regulated releases, is that regulated releases are required or mandated? That issue also framed. And is it possible to divert Godavari water to Krishna? Because Maharashtra and Karnataka have pleaded that there is substantial Godavari water is available. Andhra Pradesh has been diverting substantial Krishna water to outside the Krishna basin to Pennar and other basins, adjoining basins. So to make good shortage of Krishna waters, Andhra Pradesh shall divert its part of Godavari water to Krishna, and the Krishna waters must be available for equitable distribution. That is the demand of Karnataka and Maharashtra. So that issue was also framed. After examining the data and the statement of case and the evidences, the tribunal made following findings, are important findings. That is, first one is that 1951 agreement is void and is not binding upon the states because one of the riparian state has not signed. So though one or two states have signed, Maharashtra, Andhra Pradesh have signed, Maharashtra, Bombay and Hyderabad, Madras signed on the day, but they are not bound by that agreement because they have signed, because the other party state, Mysore, did not sign that agreement. Second one is that what is the water availability in Krishna? The tribunal has determined the water availability in Krishna as at 75% dependability. In 1951, you remember that 86% dependability was assessment. In 1970s, Bachawati tribunal assessed Krishna water at 75% dependability as 2060 TMC. That is, the upstream utilizations were added to the last point, that Vijayawada, what are the observed flows at Vijayawada. So every year from 1894, 95 to 1971, 72, 78 years data was procured, and that data, year-wise data, they have made it, they have used it, and the 75% yield is from 2060. And tribunal has also assessed that 70 TMC of return flow would be available progressively based on the utilizations made by the states. It observed that based on the allocations made by the state, it is available to them progressively. It is not a hard and fast rule. It is based on the utilizations made and the projects taken up by the states. And with regard to groundwater, it said that states are free to use groundwater, and utilization of groundwater by any state will not be accounted under the surface water use. Next one is, when the tribunal was about to start the proceedings in 1971, all the states made an agreement, Krishna and Godavari basin states, because Godavari Water Dispute Tribunal and Krishna Water Dispute Tribunal is headed by the same chairman, and the members of the Godavari basin, that is Maharashtra, Madhya Pradesh, Odisha, Karnataka, Andhra Pradesh, are also the same parties in um, 3 parties. Out of that 5 parties, 3 parties in Krishna Basin. So all the 5 parties made an agreement in April 1971, making that each of the state can divert its part of Godavari water to any other basin, and also agreed that Krishna case can be decided first. As a result, upper states can raise for a claim only out of surplus water if diverted by AP and not allocated to any state. So Andhra Pradesh contended that there are no surplus water that can be diverted to Krishna. Tribunal found that as shares of Godavari are yet to be decided, it was not possible to assess the surplus in Godavari in Krishna case. So therefore, KWDT 1, that is Bachao Tribunal, found that surplus waters of Godavari, if any, which does not belong to share of any state, are diverted to Krishna by a state, any other state can make a claim for larger share in Krishna water, and diverting state can dispute the same. That is incorporated as clause 14B in its final order. That is how KWDT 1 did not decide this issue and left open to be dealt in future. Actually, there was another agreement in Godavari which was subsequent to Krishna award, but it is relevant in Krishna. That is why I am mentioning here. On 4th August 1978, Karnataka and Andhra Pradesh made an agreement that, subject to clearance of Polavaram project by CWC, Andhra Pradesh agrees to divert 80 TMC of Godavari to Krishna at Vijayawada Anikat at 75% dependability, displacing discharges of 80 TMC from NSP and thereby enabling to use 80 TMC upstream of Nagarjuna Sagar project, and shall be shared in the proportion of 45 TMC by Andhra Pradesh and 35 TMC together by Maharashtra and Karnataka. So the gist of the agreement is 80 TMC can be diverted from Polavaram to Krishna, Vijayawada, and by virtue of that agreement, 80 TMC, the releasing of 80 TMC from Nagarjuna Sagar to Krishna Delta has to be dispensed with, because when Krishna Delta was allocated 181 TMC, it was found that 101 TMC is available downstream of Nagarjuna Sagar and 80 TMC has to be flow through Nagarjuna Sagar. So that 80 TMC, which may be required to flow up from Nagarjuna Sagar to KDS, need not be flown now, because that 80 TMC can also be utilized, because that 80 TMC supplementation from Godavari to Krishna Delta is being arranged by virtue of Polavaram project. Subsequently, Karnataka and Maharashtra agreed that out of the 35 TMC of their share, 14 TMC can be used by Maharashtra and 21 TMC can be used by Karnataka. So why this agreement was necessitated? Because the gist of the main thrust of the complaint of Maharashtra and Karnataka was that Andhra Pradesh was diverting substantial part of Krishna water outside basin, that is by disturbing the equitable share of Krishna waters for distribution. So Andhra Pradesh has to divert Godavari water to Krishna basin and thereby compensate that damage to the Krishna basin. That is their complaint. When the Krishna award was discussed, it said that the Godavari award is not taken up. So we don't know what is the available water, what is the shares, whether surplus water is not there. All those issues are pending. So that issue could not be decided. But when Godavari case was taken up, the states have said that there is abundant water, then why don't you divert? Even Andhra Pradesh also planned that Polavaram project, stating that 80 TMC can be diverted from Godavari to Krishna. So Maharashtra and Karnataka insisted that there should be sharing of waters by them also. So that is how this agreement has come. So why this 80 TMC have to be utilized within basin? There is a reasoning, as this diversion from Godavari to Krishna was required to be made by Andhra Pradesh in view of its excessive outside basin diversion. So, and this water, whatever is diverted from Godavari to Krishna, is replacing the Krishna served areas lying outside Krishna basin. So this 45 TMC have to be utilized within Krishna basin upstream of Nagarjuna Sagar. Bachao Tribunal, in the process of allocation, has found that how to allocate the water. So in making equitable allocation of Krishna waters, it considers several other international and national principles. Indus Law Commission in 1952 and also USA laws and Helsinki rules. And he observed that protection of existing uses can be made in the first instance and the balanced water can be distributed on equitable principles. Because the whatever utilizations existing as on 1960 or 19 at that standard time have to be protected and balanced water is to be allocated. So this theory, all the three states have agreed. So based on the consent of all the states, it made a finding that on September 60, whatever utilizations are there between the states, those utilizations have to be protected and balanced water has to be allocated between the states on equitable basis. So in that process, it held that it is not intended that existing users must continue and can be changed in future. So whatever protections now made, they are not sacrosanct. They can be changed in future depending upon the situation and the prevailing conditions thereupon. So states were asked to provide the lists of the existing utilizations. So they were given based on the list with the consent of the states and through findings of this tribunal, it protected 439 TMC to Maharashtra, 505 TMC to Karnataka, and 749 TMC to combined Andhra Pradesh as an existing utilizations out of the 1693 TMC. So this all total to 1693 TMC, this protection of existing users. That is almost 1700 out of 2060 TMC. So almost 85% has gone towards the protection of existing users. Only 367 TMC, very small part was left for utilization among the states for equitable allocation. So in view of the availability of less water for allocation after protection of users, the Bachao Tribunal asked their priority needs, because whatever priority needs the states have given, the tribunal tried to honor them. Subsequently, tribunal examined all the project reports placed before it and found that what are the worth consideration, what are not worth consideration based on the whether the project is serving the scarcity area and what is the rainfall in that and what is the duty. If the duty and delta adapted in the projects are exaggerated duties are there, they ask you to limit the utilization. Regarding outside basin diversion of Krishna water, the tribunals held that diversion of water for irrigation to outside basin is legal, but in equitable allocation, more weight have to be given to inside basin first. All the party states in the process of allocation after protection of existing users, the next part is that the allocation of 367 TMC on the equitable basis. So in that process, all the parties made an agreed statement in April 19 on 4th May 1973 that there should be mass allocation of available water of Krishna. That is the N block. Secondly, allocation to be percentage basis in surplus as well as deficit basis. Supposing if 1000 TMC is the available water, if 400, 200 is allocated, then in good years as well as bad years, the states have to utilize waters in that proportion only. And certain restrictions have to be imposed by the tribunal on utilization of water. And a joint control body, that is Krishna Valley Authority, is to be constituted with officers from central government and state government for giving effect to the decision of the tribunal. And the KVA has to advise the states to identify certain carryover storages across the basin, and also because the water, the fuller utilization of water was envisaged in that finding. But immediately after 17/8/1973, Andhra Pradesh declined to give its consent for constitution of Krishna Valley Authority having powers to direct states to release water going back from its area. In May 1973, it agreed for that constitution of KVA and mass allocation of water. But in August 1973, Andhra Pradesh said that it is not giving its consent for constitution of KVA. So in view of the opposition of Andhra Pradesh for constitution of KVA, the tribunal have to think once again what to do. So the tribunal, Bachao tribunal, after deeply pondering over the issues formulated two issues. One issue being scheme A, one scheme being scheme A and other scheme being scheme B. So scheme B is one scheme which they have agreed in May 1973, because they did not agree for that type of scheme, that is scheme B. Bachao tribunal framed these two schemes. This scheme A is self-implementable scheme, and states can utilize the allocated water and en bloc. So Maharashtra and Karnataka are restrained to use more than the allocated shares, while Andhra Pradesh is permitted to use their entire remaining surplus water. Supposing 560 TMC is allocated to Maharashtra, 700 to Karnataka, and 800 is allocated to Andhra Pradesh. So Maharashtra and Karnataka are restrained to utilize not more than 560 TMC and 700 TMC, and the entire remaining water, whether it is 500, 600, 1000, 2000 or whatever it may be, has to flow down to the Andhra Pradesh. So this is scheme A. But right is given to Andhra Pradesh to only that 800 TMC. It will come into force immediately without after publication of the tribunal, and it does not depend upon the agreement of the states, and no KVA is required to be constituted. Scheme B comes into force only after constitution of KVA to divide the available water each year in proportion to their allocated share. So in this scheme, the deficits or surpluses have to be shared by the states in proportion to their allocations made in each year. In scheme A, that proportionate sharing is not there. Only upper states can use up to their allocated share. Balance water, whether it is less or more, have to be used by Andhra Pradesh. So it would be wondering to know why Andhra Pradesh is opposing constitution of KVA while upper states of Maharashtra and Karnataka are welcoming. So there are 3-4 reasons. One is 70% of the yield in Krishna Basin generates in upper states, and the scheme B, whatever is formulated therein, did not contemplate releases up to the end of October. So that's how, if water is if larger storages constructed in upper states and water is not released up to October end, then every year it has to suffer. That is a big problem. So Andhra Pradesh did not agree for this scheme. So have you, as you seen this scheme A and scheme B, this scheme A is a very unique scheme compared to any other award, sir. It is not seen in any other award in India, and I think in other countries also we don't see such type of scheme. Because in scheme A, unlike other, in any other scheme like Kaveri or Narmada or Indus or in any river system, whatever water is there, that water will be shared by the states in proportion to their allocations. So whether if less water comes, less share will be used. If more water comes, more water will be used by all the party states. But in scheme A, it is not like that. So upper states are not mandated to release any water to lower state unless they realize their shares fully. No time-bound or proportionate releases are mandated in scheme A. AP has to bear the brunt of deficits in 25% of deficit years and delayed inflows, etc. In view of the same, it is permitted to use entire surplus water available in 75% years in any manner it deems proper by building carryover storages, by raising crest gates in Srisailam and Nagarjuna Sagar to the extent possible. So this is a unique feature in Krishna and not seen elsewhere. As I said, in Kaveri, Narmada or Ravi Bias and in any system, proportionate releases and proportionate utilizations are mandated in deficit as well as good year. So these are the final allocations by Bachauth Tribunal made to the states. That is, Maharashtra was allocated 560 TMC and assessment of return flow was 25 TMC. So total allocation is 585 TMC. Karnataka 700 plus 34 return flow, that is 734. Andhra Pradesh 800 plus 11, 811. So 2060 TMC in addition to return flow, that is 70 TMC. So 2130 TMC is allocated to the states. So this award came into effect from 1/6/1976, and this award will be in force up to 2000 until it is challenged by the states and another award comes. So till any other award comes and published by the Government of India in its official gazette, the KWT1 decision of this 1976 subsists, continues to be enforced. So few other relevant aspects are there with regard to Krishna case. That is, one is Tungabhadra is also there. Tungabhadra Dam was constructed jointly by the then Hyderabad state and Madras state in 19. Utilization of Tungabhadra water was planned by Madras and Hyderabad and Madras for several years, right from 1900, but no agreement could materialize up to 1944. In June 1944, one agreement was made between Madras and Hyderabad, stating that a dam at Tungabhadra can be constructed and 65 TMC of water can be utilized by each, that is Madras on right side and Hyderabad on left side at Tungabhadra Dam, and also below the Tungabhadra Dam, waters of Tungabhadra waters have to be utilized equally by Hyderabad and Madras to the KC Canal on right side by Madras and RDS of Hyderabad on left side. I will show you one small line diagram so that it will be easy to understand. In 1940s, this is the Tungabhadra Dam and this is the Tungabhadra River. The entire left side is Hyderabad state up to 1956. Whereas entire right side is Madras state up to 1953. So the agreement says that at Tungabhadra Dam, 65 TMC have to be used by Hyderabad state on left side and 65 TMC have to be used by Madras state on on right side. So, and also downstream of Tungabhadra Dam, this RTS canal by Hyderabad state on left side and this KC canal of Madras state on right side, they have to use the Tungabhadra waters equally. So this is the June 1944 agreement. Based on the June 1944 agreement, the then Madras state and Hyderabad state have started construction of the Tungabhadra Dam in a unique manner. The construction of Tungabhadra Dam is also in a unique manner because on right side, the Madras state, Madras is nothing but at that time the government of India, that is British rule in before the independence, and Hyderabad is ruled by the Nizam. So Madras state have used cement as a material, construction material on right half of the portion, whereas the left half of the portion was constructed by lime mortar by Hyderabad state. So with two types of mortars was used in this dam, left side separately, right side separately. So this is a unique structure. Nowhere in any structure in India we see this type of construction. So after construction of Tungabhadra Dam, subsequent to what happened during the construction of the Tungabhadra Dam itself in 1953, the Madras state was bifurcated into Andhra state and Madras. And at that time, the Ballari district, that is head reaches of Tungabhadra Dam and head reaches of this right half of this portion was given out to Karnataka, and the downstream portion of Tungabhadra canals came into the existence of Andhra in 1953. And entire left side remained under Hyderabad state at that time. And after 1956, once these states were once again bifurcated, the entire left side of this Tungabhadra canal came into the existence of, came into the territory of Karnataka, while RDS, the head reach came into the Karnataka territory, while the downstream of RDS, the main portion came into Hyderabad state, that is a present combined Andhra Pradesh state, and the downstream part of Tungabhadra HLC and LLC came into the Andhra Pradesh territory. So subsequent to bifurcation of Andhra state in 1953, right half of Tungabhadra Dam and head reaches of right canal fell in Mysore state, while lower reaches fell in Andhra state. So because of this combined nature of canal and these structures, Government of India, President of India issued one order as per the 1966, Section 66 of 1953 Act. The Tungabhadra Board was constituted as per the presidential order, having a charge and control of right half and right side canals of common canals. So left half of dam and left canals were under the control of Hyderabad, and later they were under the control of Karnataka. So they were not under the control of Tungabhadra Board. Only the right half of the dam and the left side, right side canals, HLC or LLC, were under the control of Tungabhadra Board. So the Section 66 of Tungabhadra Act says the rights of the erstwhile Hyderabad state with respect to Tungabhadra Board were to be the rights of Mysore and Andhra states, as to be agreed upon by them within 2 years. Else, President will provide for the same. Because you see that utilization of Tungabhadra waters as per June 1944 agreement provides for left side entirely to Hyderabad state, right side entirely to Madras state. So that part of Madras state, which is the share of Madras state, is now the share of Karnataka and Andhra Pradesh, has to be agreed upon by them as per the Section 66 of Andhra State Act. So if in case both the states cannot come to an agreement within 2 years, the president will provide for the same. That is the Section 66 reads. But there was no such agreement by the states. In 1971, when the Bachao Tribunal proceedings are happening, both Karnataka and Andhra Pradesh made an agreement on utilization of Tungabhadra right side waters, that is HLC and LLC. As HLC, Andhra Pradesh 29.5 and Karnataka 22.5. LLC. HLC 32.5 to Andhra Pradesh and 17.5 to Karnataka. Further, both Karnataka and Andhra Pradesh also requested tribunal for setting aside deciding the issue of validity. In the initial part, we have seen that whether the agreements of 1892, 1933 and July 1944 and June 1944 agreement are valid or subsisting, and are they bound by the states? There is an issue to be decided by the tribunal. So what happened in January 1971, Karnataka and Andhra Pradesh gave a giant statement, made a giant statement before the tribunal stating that you need not decide about the validity of this agreement. Therefore, the very basis for construction of the dam and sharing of Tungabhadra waters was set aside, but they have made a separate agreement departing from the June 44 agreement. Based on, because this 1944 agreement was set aside, the tribunal protected an utilization of 39.9 TMC to KC Canal and 59 TMC to RDS of Andhra Pradesh. If you see that earlier, as per June 1944 agreement, this RDS and KC Canal have to use waters of Tungabhadra equally. But because this agreement is set aside and the waters of Krishna were allocated based on the protection of existing uses, the KC Canal got an excess protection for 39.9 TMC, whereas RDS was protected for 15.9 TMC. So that is how there is a go by to that June 44 agreement. While making this award, the Bachao has dealt on several occasions that whether this award has to be a review provision has to be provided in the award or not. So he felt that population, engineering, economic and irrigation and other demands, they continue to change constantly. That is why this award required to be reviewed after a reasonable time, that is after May 2000. If any state makes any complaint, then this award can be reviewed. So what to be reviewed? So it is an important question. So under Scheme A, we have seen that the important feature of Scheme A is that the entire remaining water was given to lowest riparian state of Andhra Pradesh, whereas Maharashtra and Karnataka were restrained to use only limited quantity of water. So at that time, Andhra Pradesh projected that basically it has two difficulties. One is inevitable flows. Secondly, in 25% of years, Andhra Pradesh is going to suffer more than upper states, because out of the 2060 TMC available in Krishna Basin, almost 1000 TMC is generated in Maharashtra, 700 TMC in Karnataka, and 360 TMC is available or generated in combined Andhra Pradesh. So when less water, that is about 1500 or 1400 TMC is generated, is available in any extreme drought year, what happens? Out of 1000, even if 600 TMC is available, Karnataka will be, Maharashtra will be able to utilize their share fully, or otherwise at least 90 or 95%. Karnataka will also be utilizing their share almost 80 to 90%, whereas it is Andhra Pradesh, the combined Andhra Pradesh will suffer more. That is, the larger sufferance, that is 400 or 500, 90% of that deficit have to be borne by the combined Andhra Pradesh. So that is how it made out a case that in 25% of years, combined Andhra Pradesh will suffer more. That is why it has to be permitted to utilize the entire surplus water. So therefore, while reviewing the award, while allocating this provision to the Maharashtra, Karnataka, and Andhra Pradesh, so Bachao Tribunal thought that because there was no gauge data, sub-basin wise gauge data was not there, so it was unable to assess the benefit of the surplus water and the quantity of loss to the combined Andhra Pradesh due to one, inevitable wastage, secondly due to this extreme deficits in 25% of years. So they could not balance the equation, the benefit of surplus water and the deficit due to 25% of bad years. So they have simply given up, equalized these two unknown quantities and gave it to Andhra Pradesh. So now, after availability of sub-basin wise gauge data and detailed study, so the balancing of the surplus water or anything is possible. So whatever surplus water that is available in excess of the deficits to Andhra Pradesh, the combined Andhra Pradesh need to be can be distributed between all the states again. So one more issue is Bachao Tribunal formulated one draft scheme. So Karnataka was advocating that scheme B has to be enforced because under scheme B it gets a larger share. As formulated by the Bachao, the scheme B contemplates 25% to Maharashtra, 50% to Karnataka, and 25% to Andhra Pradesh in over and above that 560, 700, and 800. So because you have seen the waters of 560, 700, 800 is the allocation of water. So whenever more waters is available in Krishna, 25% is available to can be used by Maharashtra, 50% can be used by Karnataka, and 25% is available to Andhra Pradesh. So that's how they will. Karnataka can get larger share out of the surplus waters. So they prefer that scheme B can be implementable and scheme B has to be enforced. Whereas Maharashtra, though Maharashtra inclined for scheme B in the first instance, but they have also changed it to shifted their mind to scheme A later. And any changes in the availability of water and any stupendous advancements in conservation of water, all these things needs to be examined in while reviewing this tribunal award. This is another thing which required to be done. The states have started construction of projects, utilization of water, and clearance of projects, and everything was going on after this award came into force in June 1976. But subsequently, based on the liberty granted to the Andhra Pradesh to utilize the remaining water in any manner it deems proper, Andhra Pradesh has taken up several projects on surplus water based on that liberty. So it has raised several claims by Karnataka and Maharashtra. They have started addressing government of India, stating that no, don't permit Andhra Pradesh from taking up surplus based projects, because Andhra Pradesh again starts using these surplus based projects and they will claim for a right over continued usage of waters. So this shall not be allowed. That is the claim of Karnataka, and Maharashtra also joined tone with Karnataka. And Karnataka also started constructing the Almaty Dam, the part of UKP, that is Upper Krishna project, up to a height of 524.256 meters. So Almaty being in the center of the basin, and if it capacity was raised from 100 TMC to 200 TMC, much larger water can be stored. So the Karnataka plan is to raise Alamatti Dam up to 524 TMC, that is to store 230 TMC, and they can generate power and utilize water. That is their plan. So in 1997, Karnataka filed original suit before Honorable Supreme Court contesting that government of Andhra Pradesh, the combined Andhra Pradesh, was taken up several projects based on the surplus waters of River Krishna, and it is going to preempt their forthcoming right over surplus waters, that is that any time to be constituted by a tribunal after 2000. So Andhra Pradesh is going to curtail their share. So they claimed that all the surplus water basis projects of Andhra Pradesh have to be restrained by the Supreme Court. They have asked for a restraint order over Andhra Pradesh, all the surplus based projects of Andhra Pradesh. Simultaneously, Andhra Pradesh also filed one more OS before Supreme Court requesting to restrain Karnataka from raising the Alamatti Dam not more than 519.6, and several other projects in Tungabhadra also. So Honorable Supreme Court in May 2000 gave its verdict. So elaborate arguments were taken place before tribunal. Almost 13 issues were framed by Karnataka, whereas 22 issues were framed by Andhra Pradesh. After dealing all the issues, the tribunal said that while dealing with the issue of restraining Andhra Pradesh from taking up surplus-based projects, Supreme Court directed that it is central government to exercise the discretion what is really meant by the liberty granted while clearing the projects of Andhra Pradesh, so that there should not be any apprehension in the minds of upper states that for all times to come, the right of using surplus water would be endangered in any manner. So they did not restrain Andhra Pradesh projects, but they say that Government of India or CWC has to exercise its discretion whether the surplus-based projects can be cleared or not, which would endanger the right of upper states. So based on the decision of the tribunal or anybody on the shares of surplus water, anybody, that can be decided. Secondly, with regard to OS2, Honorable Supreme Court held that the Karnataka can go ahead with up to 519.6, that is with a storage of 130 TMC, and beyond 519, that is up to 524 or any other height, that can be dealt by a tribunal to be constituted when all the states made any complaint to the Government of India for constitution of a tribunal. And thank you very much, sir. This is all I wanted to share with you. And the remaining part, that is with regard to remaining items of Krishna, I will share you in the next session, sir, on October 5th. That is how the complaints were made by the states and emergence of KWDT2 and the allocation process made by the KWDT2 and the reorganization of states and the issues with regard to river management boards and other issues. We will deal in October 5th session and 12th October session. So this is up to 2000 I have incorporated in this session, sir. So if there are any doubts, you are most welcome to raise, sir.
Thank you, sir. Now the floor is open for question answer session. If there is any question, you can write down in chat box or you can directly ask to our speaker. Sir, there is one question from Radha Krishnan. He appreciates the speaker's expertise on subject. However, he would like to point out minor inconsistency in interpretation of clause 14b, which state that this clause ensures that if there is any change in Krishna river water flow due to diversion of water from another river, another river, states can both make claim for large share and dispute such claims without any restriction on barriers. This clause applies to all situations, not just surplus water as mentioned by the speaker. I request the speaker to clarify this point.
Sir, thank you, sir. Thank you for raising a very genuine question, sir. Actually, the description of these details are available in the Bachawat report at page 33, 34 of the further report, sir. Where because fundamentally all the states, Maharashtra and Karnataka, complained that the surplus waters of Godavari have to be diverted to Krishna Basin to make good the deficit in Krishna Basin by Andhra Pradesh, because Andhra Pradesh is diverting Krishna water to outside basin. So there is a deficit in Krishna Basin. To meet that deficit, they are mandated to divert Godavari water to Krishna. But the initial agreement in April 1971 says that each of the state is at liberty to divert their part of Godavari water to any other basin. So by virtue of that agreement, no state can claim that you claim for a share out of the dependable waters. So whatever surplus waters that is diverted from Godavari to Krishna can only be subject matter in this. Sir, this is available at page 34 of Bachawat report, further report, sir. I will read out. We find that there can be no serious objection to the, otherwise shall I share the screen, sir? Sharing screen. I will share the screen, sir. 1 second. Just please bear with me for a minute, sir. Sir, you can see from here after May 2000, we find that there can be no serious objection to reallocation of Krishna waters as soon as there is augmentation of waters of river Krishna by diversion of surplus waters, if any of the Godavari, which is not part of the equitable share of any state in Godavari waters. So this is the finding of the tribunal, but it has the details are not enshrined, listed in the final order, sir, but it is available in the report. That is why I said that the surplus waters, if any, which does not belong to share of any other states, is diverted by any state from Godavari to Krishna, each of the state is at liberty to claim for a share. This is from page 34 of KWDT to further report, sir. KWDT 1, Bachawat report.
Yes, any questions, please? So there is one question. Comprehensive lecture is there. Is there any deadline for KWDT2? If no, what is your opinion? Likely completing date?
They're asking some questions here. Here they're asking questions. What are the
Rao sir,
exact?
yeah, Rao sir. One participant is asking, is there any deadline for KWDT2? If no, what is your opinion? Likely
Is
to be
there
completing
deadline for
date?
KWDT2? If no, actually KWDT2 is also to be reviewed after 2045 or sometime they have given. I will tell you that date, sir. They have also given a review date. KWDT2 award, actually it did not come into force, sir, because it is not published. There is a ban by restraint order by the Supreme Court. So these details we are going to deal in the second session. But anyhow, even after publication of KWDT2 report, it is also up to limited period. I think up to 2050. That is any time after 31st May 2050, KWDT report may be reviewed. There is a date for that one, sir. Next question.
Thank you, sir. Next question is, what are the exact disputes of Andhra Pradesh and Telangana states over Sri Sailam project about water allocation and uses and power generation?
Actually, sir, basically, Sri Sailam project was sanctioned by Planning Commission in 1963 as a hydroelectric project for supplying water to Nagarjuna Sagar Dam. That is their purpose. So, subsequently, the water, the other part of Sri Sailam is Bachao Tribunal allocated only 33 TMC towards the evaporation losses, and they did not allocate any water for the consumptive use from Sri Sailam Reservoir to outside basin on right side. They also stated it very well, very clearly that no water is to be diverted from outside basin from Sri Sailam to. Even after that, Andhra Pradesh has taken up several schemes from Sri Sailam. So that is a big question, and that is a subject matter before British Tribunal. So power generation, it is only Sri Sailam is only contemplated for power generation and for releasing water to the Nagarjuna Sagar.
Thank you, sir. Any questions, please? Any more questions?
I am seeing the from the chat box. I am.
Yes. Any more questions?
Some PR Rao, Mr. PR Rao, deficit Rayalaseema is the most neglected area and suffered due to not linking of rivers. So some surplus water, whenever it is available, definitely can be thought of diverting to Rayalaseema area. It is not a problem, sir. But that is an issue to be decided after this Bachao report, the Brijesh Kumar report is decided. So very comprehensive nature deadline. So the deadline of KWDT is May 2050. Yes, sir. CEWRDO has given this. Okay.
Thank you, sir. Any more questions, please? Okay, then we conclude the session. On behalf of National Water Academy, Central Water Commission, Pune, I extend my heartfelt gratitude to all esteemed participants, speakers, and attendees for joining us today for this enlightening webinar on interstate river water disputes in India. We are extremely grateful to our distinguished speaker, Shri Koteshwar Rao sir, for sparing his precious time and sharing his extensive knowledge as well as experience on the Krishna Water Dispute Tribunal case study. I would like to extend a special word of thanks to all participants who actively engage in panel discussion as well as question answer session, and throughout this session, your contribution enriched the deliberations and help foster for vibrant exchange of ideas. Further, I would like to express our sincere gratitude to Secretary DOWR, RD and GR, then Shri Ora sir, Chairman and ex officio Secretary to the Government of India, Central Water Commission, then Shri D.H. Chaskar sir, Chief Engineer and Head of National Water Academy, who is driving force behind the various activities of National Water Academy, and with his generous support and guidance making NWA to venture ahead. Last but certainly not least, I would like to thank our dedicated team at National Water Academy, Pune. Thank you once again to everyone who has been part of this webinar. We look forward to future endeavor and collaboration in our pursuit of resolving interstate river water disputes in India. Now, the next session will be on 5th October 2023 on Thursday at 11 a.m. and the topic will be interstate river water disputes in India, challenges of Krishna Water Dispute Tribunal case study part 2, and the speaker will be Shri Koteshwar Rao sir, former superintending engineer, Government of Telangana. Similarly, our another webinar series is also starting simultaneously on international cooperation in water sector of India. Their next session will be on Tuesday, 3rd October 2023, and the topic will be International Water Law, UN Water Course Convention 1997, and other instrument, and speaker will be Shri S. Siddiqui. The webinar link as well as flyer will be shared on both topics on our WhatsApp group as well as your registered email ID. Okay, we will meet on Tuesday for international cooperation and on Friday on the Interstate River Water Dispute Tribunal. Okay, thank you. Namaskar.